My name is Dr. Rachel Kuntz. I am a criminal justice faculty here at Wayne State College, and I've had the distinct pleasure of advising Trinity Seery on her honors project. She'll be talking today about capital punishment and whether it should be available and applied in every state. And I know she worked really hard on this, and I'm excited to see her present. So,
thank you all for coming. So as she said, I'm presenting about capital punishment and should it be available and applied in every state. So the creation of capital punishment was created as an early method of crime deterrence and became a common response to many types of crime. The Code of Hammurabi was one of the earliest written documents that supported the death penalty. The code was created around 1760 BC and contained 282 laws collected by the Babylonian king Hammurabi. The death penalty is also supported by the Jewish Torah, the Christian Old Testament, and the writings of an Athenian legislator named Draco. Since its creation, capital punishment has also served as retributive justice, or an eye for an eye. This is rooted in the idea that those who commit severe crimes deserve to face a punishment that corresponds to the harm they caused. It is also seen as a tool for social order and control. In some societies, the fear of execution was thought to contribute to a sense of stability and security. Lastly, it was seen as a religious or moral justification, which will be discussed more in depth in the next part of this presentation. Creating a public spectacle. Over time, an extensive process was developed for the spectacle of being executed. The condemned were dressed in special clothes and taken from confinement to the place of execution by a horse-drawn carriage. Before execution, religious leaders delivered homilies, and the sheriff would either read the warrant or make up his own speech. Then the condemned would give their final words, followed by a hymn or a prayer. After this, the execution would then take place. These were made into public spectacles, and around 1,000 people would come and witness these events. This included women and children. This was because these events were rare and performed in rural areas. People would travel long distances to witness these executions for a wide variety of reasons. One of these reasons was morbid curiosity. Humans have a natural inclination to witness dramatic or shocking events. The second reason was entertainment. Public executions created a way to break the monotony of daily life and were sometimes accompanied with rituals, ceremonies, and even a carnival-like atmosphere. Public executions served as a deterrent to potential criminals. Authorities believed that a public display of punishment would instill fear in the population and discourage others from engaging in criminal behavior. Cultural and societal norms also played a role in these public spectacles. These executions were seen as a communal event where people gathered to witness and discuss matters of justice and punishment. Some people would also attend these events to reaffirm their moral convictions. They saw these acts as divine justice and saw this as a way to align themselves with moral or justice and punishment. Lastly, politics played a major role in this. Authority used public executions as a way to assert control over the population. Since these executions were so public, it reinforced the power of the ruling class and served as a reminder of the consequences of disobedience. However, over time, people's attitudes toward public executions have changed. This shift is linked to evolving ideas about justice, human rights, and the dignity of individuals. But even today, while not as public, people can still witness offenders be put to death by watching through a viewing window. This takes place in a private and controlled area, often within a prison. For example, someone could witness an offender be put to death through a window by lethal injection. The first types of punishment. The first types of punishment that were more popular were crucifixion, the use of a guillotine, and the act of drawing and quartering. As time went on, society named these forms of punishment as cruel and unusual. During the 18th and 19th centuries, hanging and beheading became a new method of capital punishment, and while they're still considered a spectacle for society to watch, these methods were deemed to be more humane. Capital punishment has been in the United States since the original colonies and has been used for a wide variety of crimes. Some of these crimes included burglary, counterfeiting, arson, and also more serious crimes like murder or treason. Around the time of the American Revolution, lawmakers began revising policies about the death penalty. In 1791, any form of punishment that was considered cruel and unusual was prohibited under the 8th Amendment in the U.S. Constitution. This was the beginning of new humane forms of punishment, such as the electric chair and lethal injection. So the evolution of capital punishment. The use of electricity first appeared in 1883 as a painless way to slaughter cows, and appeared 2 years later as a means to execute criminals. A commissioner by the name of Southwick was an advocate for death by electrocution after witnessing a man die in Buffalo, New York, after making contact with a live wire. He performed experiments on animals, and this further convinced him that electrocution was the best option. The Jerry Commission of New York looked for other options for the death penalty, a total of 34 different options, which even included death by lethal injection using a drug or poison. However, they strongly advised not using a medical instrument to kill someone, even though it promised a quick and painless death. Dr. Southwick asked Thomas Edison what he thought about using the electric chair as a form of punishment. Even though Edison initially rejected this idea, saying that he preferred life imprisonment over any other form of punishment, eventually Edison changed his mind, and along with Elbridge Gerry, because the electric current was used to kill someone was different from Edison's own electrical generating system, they agreed. In 1888, the Jerry Commission presented their reports about using an alternating current to produce a death that was quick and painless. During that same year, the legislature of New York passed the Electrical Execution Act. This meant that anyone who was sentenced with a capital crime after January 1st, 1889, would be put to death by electrocution. William Kemmler was the first person to die by electrocution for killing his girlfriend Matilda Ziegler with a hatchet on March 29, 1889. He was convicted on May 10th and sentenced to death by electric chair 3 days later. However, he remained on death row for over a year. Lawyers appealed his sentence under the grounds of cruel and unusual punishment. However, the Supreme Court of the United States said that they could not interfere with the legitimate act of the New York legislature. After countless attempts by his lawyers to keep him safe from electrocution, it failed, and he was put to death on August 6, 1890. So some culture surrounding the capital punishment. In 1972, the United States Supreme Court deemed that the death penalty was unconstitutional because it was not being applied properly. In return, many states decided to rewrite their laws to preserve the death penalty and to meet the court's requirements. In 1976, the death penalty resumed, and it was only sanctioned for the worst of offenders in hopes that it would eliminate the arbitrary application of the former punishment laws. One major case that supported the death penalty was the Oklahoma City bombing in 1995, when Timothy McVeigh bombed the Alfred P. Murrah Federal Building. After this incident, Congress passed the Anti-Terrorism and Effective Death Penalty Act of 1996 in order to speed up the death penalty process. The terrorist attacks in New York and Washington, D.C. on September 11, 2001 resulted in many proposals to expand the death penalty even further. Even with these attacks and the high level of support from the public and its affirmation through the electoral process, the death penalty has been in decline since the year 2000. So who is capital punishment actually applied to? The death penalty is currently authorized in 27 states in the U.S. and is approved in these states from the federal government and the U.S. military. Nebraska is one of the 27 states that has capital punishment as an option. While the Nebraska legislature abolished capital punishment in 2015, it was reinstated a year after due to a statewide vote. Since 2015, 25 states have enacted 66 new laws addressing how the capital punishment system works. These new laws include expanding or limiting aggravating factors, modifying execution methods and procedures, and changing trial and appellate procedures. Rulings on who the death penalty is actually applied to. Atkins v. Virginia, 2002, was from the Supreme Court deciding that the death penalty is prohibited for offenders who are intellectually disabled. The court cited that the growing number of states prohibiting the execution of persons with mental deficiencies is a reflection of society's views. This is because society views these offenders as less culpable than the average criminal. Roper v. Simmons, 2005. The U.S. Supreme Court ruled that it is unconstitutional to impose a death penalty for a crime committed by a child under the age of 18. The Supreme Court came to this ruling based on the fact that a death sentence imposed on a minor violates both the 8th and 14th Amendments. This is because a child's brain, along with their bodies, are not fully developed and do not have the ability to make adult levels of judgment or to assess the risks and consequences of their actions. In Kennedy v. Louisiana, Patrick Kennedy was sentenced to death in 2004 for raping his 8-year-old stepdaughter. Kennedy challenged his sentence on the basis that this was a violation of the 8th Amendment because of the rarity of his crime. After reviewing the case, the U.S. Supreme Court decided that the death penalty for the rape of a child where the victim did not die was unconstitutional. Ring v. Arizona played a very important role in capital punishment. During this ruling, the Supreme Court decided that a defendant had the right to a jury rather than just a judge. They also decided on the existence of an aggravating factor that makes a defendant eligible for the death penalty. First v. Florida is an extension of Ring v. Arizona. Florida's death sentencing scheme was found to be in violation of the 6th Amendment in light of the Supreme Court's recent ruling in Ring v. Arizona. The outcome of this new ruling was that a jury must unanimously find the critical findings necessary before the trial court may consider imposing the death sentence. So the Supreme Court's ruling on the death penalty. The 8th Amendment was put into place to ensure that nobody would face cruel or unusual punishment. The Supreme Court has ruled that the death penalty does not violate these rights and that the 8th Amendment shapes certain procedural aspects regarding when a jury may use the death penalty and how it gets carried out. Over many years, the Supreme Court has updated the law concerning how the death penalty is used. In 1972, the death penalty was banned after Furman v. Georgia because it invalidated the existing penalty laws and was deemed cruel and unusual. The court's reasoning behind this was that it discriminated against impoverished and minority communities. However, in Gregg v. Georgia, 1976, the death penalty was reinstated because the court held that it was not per se unconstitutional since it could serve social purposes such as retribution or deterrence. Another update to capital punishment happened in 1977 in the ruling of Coker v. Georgia. The Supreme Court held that the punishment must be proportional to the crime. If it is not, then it violates the 8th Amendment. A proportionality analysis is looked at when deciding capital punishment as a viable option. The three factors include consideration of the offense's gravity and the stringency of the penalty, consideration of how the jurisdiction punishes other criminals, and consideration of how the other jurisdictions punishes the same type of crime. Society's views on capital punishment. According to an April 2021 Pew Research Center survey, most U.S. adults support the death penalty for people convicted of murder. 60% of all who took the survey either somewhat or strongly favor the death penalty for persons convicted of murder. 64% of people also found that the death penalty is morally justified when someone commits a crime like murder. That means 9 in 10 people thought the death penalty was the best option. Another study showed that those who oppose abolishing the death penalty because of the innocent people that may be executed argue that the fact that some death row inmates have been exonerated proves that the checks and balance system to prevent innocent people from being executed is in place and working. This helps eliminate the chance that an innocent person will be executed. Proponents who argue that medical professionals can participate in executions ethically state that doctors and others ensure that the execution is not cruel or unusual. This is because they are ensuring that the person being executed receives medical care during the execution in terms of the proper dosage and in administering the drugs in the correct and most effective way. Lastly, looking at the federal death penalty, a majority argued that justice must be carried out to offer closures to the family, and that the federal government has an obligation to enact the sentences handed down by the courts. So there has been a decline in the death penalty. Overall, there has been a steady decline within the past years in the U.S. At the end of 2019, a total of 2,570 people were on death row in the United States. This was down 29% from the end of 2000, with a total of 3,601 people. The number of death sentences given has also declined dramatically. Only 31 people were sentenced to death in 2019, which is far less than the more than 320 people who received death sentences each year from 1994 to 1996. Annual executions were also found to be far below their peak level. In 2020, a total of 17 people were put to death nationally. This is the fewest number of deaths since 1991, and is far below the modern peak of 98 in the year 1991. Even with COVID-19 disrupting legal proceedings, this number is still way below the typical number of deaths. The Trump administration has since executed 10 prisoners in 2020 and another 3 in January 2021. The federal government has also only carried out 3 executions since 1976. However, since the Biden administration took over, there has been a different approach. In July 2021, Attorney General Merrick Garland, ordered a halt to all federal executions so the Justice Department could review their policies and procedures. New safeguards to protect innocent people. Since the 1970s, there has been no proof that an innocent person has actually been executed since increased safeguards and appeals were added to the death penalty. According to the Justice Project, the Innocence Protection Act was a law created to give individuals access to DNA testing. This bill was first proposed in 2001 and was introduced in both the Senate and the House of Representatives. Early versions of the Innocence Project Act were very wide-ranging. There were two pillars of this bill. One pillar was to expand access to post-conviction DNA testing, and the second pillar was to make improvements in the system by which states appoint defense lawyers for indigent capital defendants. In late 2003, the sponsors who were in favor of the bill engaged in intense negotiations with two members of the House and Senate. Eventually, their sponsors won their support. However, this win was steep. Instead of a broadly applicable right to post-conviction DNA testing, the compromise bill established a procedure for federal prisons to obtain testing. Oklahoma's new death penalty plan. Oklahoma's Court of Criminal Appeals has set dates for 25 out of 43 of the state's death row prisoners. These dates were scheduled for execution every month from August 2022 through December 2024. These executions are set to take place in 4 phases with 6 executions each, plus the additional 25th execution to complete the phase. Each phase includes 6 executions set at 4-week intervals. After this execution, there is an execution-free month, which marks the beginning of a new phase. James Cunningham is the first person to be put to death with this new plan. His execution date was set for August 25th, 2022, and he was put to death on this date by lethal injection. This plan is still ongoing today and is on track to finish next year in December. Florida's new legislation. On April 20th, 2023, Florida Governor Ron DeSantis signed a bill into law allowing for the imposition of the death penalty when the jury makes a recommendation for the death penalty with a vote of 8-4. Then on May 1st, 2023, an addition to this was made by DeSantis when he signed a bill to expand capital punishment in the state. This expansion allows for the death penalty to be imposed for certain sexual crimes committed against children. This holds true even if the victim does not die, despite existing Supreme Court precedent that limits the death penalty to offenses that cause the victim's death intentionally. Florida joins Alabama as one of the only states that allows for a sentence of death without a jury's unanimous recommendation with the new non-unanimity law. Florida came to this new non-unanimity law after the Broward County jury failed to come to a consensus for Nicholas Cruz. Cruz took the lives of 17 people at Marjorie Stoneman Douglas High School in Parkland, Florida in 2018. Since the vote was not unanimous, Cruz will receive the punishment of a life sentence without the possibility of parole rather than being sentenced to death. The outcome of this case led some people being concerned about the arbitrariness of the application of the death penalty in the United States. Lastly, there are too many pros to abolish the death penalty. The first pro is how the death penalty is considered to be the most appropriate form of retribution and deserve punishment for the worst types of crimes. Rehabilitation for these types of offenders is almost impossible, and for some, life in prison could only increase their criminal behavior. Therefore, the death penalty is a preventative measure for offenders recommitting these crimes, and for the protection of society from these criminals. Another pro for keeping the death penalty is that the death penalty saves lives. A Gallup poll found that 61% of Americans view the death penalty as morally acceptable. Even those who oppose the death penalty vocalize their standing loudly. Americans have constantly supported the capital punishment by a 2-to-1 ratio for murder cases. Other investigations conducted using a variety of samples and statistical methods have demonstrated a strong link between executions and reduced murder rates. A study done in 2003 by Emory University found that more than 3,000 counties from 1977 to 1996 found that each execution resulted in an average of 18 fewer murders per county. In a separate study from 1978 to 1997, Federal Communications Commission economist Paul Zimmerman collected data from all 50 states and found that each state execution deters an average of 14 murders annually. A more recent study from 1994 to 2005 by Canada's Atlanta Duke University found that each execution in Texas was associated with short-term reductions in homicides. a decrease of up to 2.5 murders. A few years later, in 2009, researchers found that adopting state laws that allowed defendants in child murder cases to be eligible for the death penalty was associated with almost a 20% reduction in these types of crime rates. The last pro I will discuss is clemency. Clemency is a process by which a governor, president, or administrative board member may reduce a defendant's sentence or even grant a pardon on their sentence. Death penalty cases have been granted clemency for a variety of reasons. It has been granted to those who are mentally disabled, a co-defendant who is given a lesser sentence, inadequate legal representation, or evidence that led to wrongful conviction. That is all. Thank you for coming.